Welcome back to my channel. My name is Mark Torche. I'm a patent attorney. I have my own practice. I specialize working with private inventors and small businesses. I give you a little background about myself. I'm originally from New York, upstate New York. Uh, Worked for some law firms in Manhattan, down in Fort Lauderdale. Uh, Branched out on my own for the last about 15 years. Uh, really enjoy working with private inventors, very inventive people. My dad was an inventor, just fascinating stuff. Used to watch him work on his projects. Wish I could have been there to help him more, but wasn't able to till later in life. But thought I would talk to you today about something fundamental to patent law, and that is what exactly is a patent. First off, a patent is a creature of statute. It does not exist except through what the government grants. It is in the Constitution, often in Article 1, Section 8, Clause 8 of the Constitution of the United States. It says it grants the Congress the enumerated power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. It's often referred to as the Patent and Copyright Clause. Interestingly, patents, separate from copyright, even though they're both discussed in this clause, patents don't really have any existence except from a statutory authority. Copyrights, like trademarks, also have a piece of their functionality that comes from what's called natural law rather than the statutory. So patents, you really have nothing there, even though we call it intellectual property. And we can talk about property in general. What makes property? You think of property as, well, in law school we used to call it a bundle of rights, if you like, a bundle of sticks. What could you do to it? You could sell it, you could give it away, you could do part of it, you could lease it, you could separate the bundle and give only partial rights away. There's a lot of different things you can do with what we call property. And a intellectual property, we say the same thing, but those rights don't come, for a patent, the rights don't come into existence until you actually file something. And even when you file something, the rights are only there partially, because you have, as soon as you file for a patent in this is the United States law that I'm talking about. Most countries have something similar, but I'm not talking about other countries right now, really talking about the United States. When you file a patent application with the United States Patent and Trademark Office, you have a legal status called patent pending. Patent applied for, same thing. You have this status. And what does it mean? A lot of clients come and they ask me, oh, now that I've applied for this patent, can I stop somebody from copying me, etc.? And the short answer is no, not yet. You have a legal status called patent pending, but you really do not have your full-blown rights in the patent yet, in that invention. And by the way, a patent is not for an idea. You cannot patent an idea. You must patent an invention. Now, what is that? That's a little bit blurred line there, because where does it cross from an invention, as an idea, to an invention? Really, it's the idea as it's embodied in some physical form, some actual invention. And there's, like I say, there's definitely overlap. It's the inventive stuff must be there, but you can't just file for an idea. Patent office will reject it. You'll be wasting your money. But when you apply for the patent and you get the patent pending status and you get patent applied for status, you cannot stop anybody from copying you at that point. It's just until you get an issued patent. And I say until. It takes 2, 3, 4 years, and there's no guarantee. You might pay that money and never get issued a patent. The patent office is there to grant the patent. There's debate about that. The statutes that sets up it basically says you are entitled to a patent unless, some people like to debate, the patent office often seems to take, at least from the practitioner side of trying to get patent, that you are not entitled to a patent unless you can prove you're supposed to get the patent. But regardless of that technicality, you're not supposed to get a patent if it's already public. You're not supposed to get a patent. Why not? What is a patent? What's the purpose of the patent? Isn't it there to protect the inventor? And in reality, no. The American system, our forefathers looked at many different countries when they were devising the Constitution. The reason it's in the Constitution is we're basically skeptical in the United States of monopolies. We don't really like them. We like free market, theoretically anyway. We like free market economy. Everybody can compete. You do it better, do it faster, do it cheaper, you deserve to succeed where the other person will fail. So why is it with a patent it's exactly the opposite? We're saying no one else can make or sell your product except you, if you're the patent owner. We do that it's a trade-off. If you notice in the Constitution, it says for limited time. So we're going to give you a limited time monopoly, strictly statutory. It has changed throughout the course of history. Right at the present moment, it's 20 years from the time you first apply for the utility application. Doesn't count a provisional filing, which I'll talk about in another video, what are the types of filings. But for what you normally think of as a patent, the utility patent, it is 20 years from the time you first file. So if it takes you 4 years to go through the patenting process and get it, you're going to have 16 years left on your patent term. And then it goes away. And not only does it go away, it's now in the public domain, because in order to get a patent, one of the requirements is that you completely disclose how to practice, how to make your invention. So now the entire body of the country is been elevated by your invention. The knowledge base is upgraded by your invention. And that was the trade-off of it. We're going to give you a limited monopoly, but we think that that's the way to increase the science base, the inventive base, the economic base of the country, is to bring new products to market, bring new ideas, bring new innovations to market. It's expensive. It's easier to just keep doing what you're doing. It's always a risk to bring something new to the market, etc. So to encourage that, people taking the risk, they wanted to promote it by the patent, so that you have a certain amount of time to try to recoup all that investment and all that risk that you took. And that's the purpose of the patent. So it's not there solely. I mean, it's not solely to protect the inventor. It's really there to increase the knowledge base of the country, and they feel that the founders felt that the way to do that, the way to encourage increasing, was to go ahead and offer protection to the inventors bringing something new to market. So that's basically the purpose of the patent. You have to, as I was saying before, patent pending. What does it do? It puts the nation, puts the other people, puts your competitors, puts people on notice that you have applied for a patent. You can't stop them. You would be premature to say, I'm going to cease and desist, I have a patent application on file, stop doing what you're doing. Let's say, I'll give you a scenario. So you file for a patent application and you start selling your product. Somebody buys your product, looks at it, reverse engineers, or looks at your patent application if it's published, and starts making it, competing against you. You cannot send them a cease and desist letter. You could send them a letter and say, you might be interested to know that we have a patent application on file. Why would you want to do that? Well, if they insisted on competing with you while there's a patent application on file, if your patent is granted, you can then you can sue them for infringement. And not only if you gave them notice of it, and even if you didn't, you can show that they should have had notice. You can sue them for willful infringement, which means triple damages. You can get your lawyer's fees paid for, perhaps. That's if it's egregious. And it's a little easier to prove. You sent them a letter 3 years ago telling them that there was a patent application on file, and they decided to go ahead anyway, assuming that you wouldn't get the patent. If you get the patent, you can then your rights blossom to a full set of rights that you get to act on legally. But until that point, patent pending is just puts the world on notice that you have applied for a patent, and makes them aware that they're taking a risk if they go forward, that they could be sued for infringement if your patent is granted. They once it's published, and patents today are published unless you choose not to, and there is a very small. You do have one option in the United States to not publish a patent application, and I'll talk about that in a separate file because it's not really germane to this discussion. But normally, 18 months after you file a patent application, and that 18 months does include if you filed a provisional application, 18 months after you file, it will be published, and everyone will have access to it. Whether or not the patent is granted, even if the patent is eventually abandoned, you tried, you just didn't get it, it will be public knowledge. And somebody can look at it. So if you have patent pending and you're out there selling it and a company looks at it, they can examine, if it's been more than 18 months, they can examine your patent application. If they feel like it's not going to get, they can put their attorneys on it and look at it and say, nah, no way, they're not going to get this patent. They might take the risk. So it is a risk. But it's a big risk, like I said, especially the attorney's fees. Patent litigation is expensive, and if you've got a good case of it looks like willful infringement, you're very likely. I don't do litigation, so I don't want to talk too much. But if you've got a pretty strong case of willful infringement, you could probably find a patent attorney that would take the case on a contingency basis. So you wouldn't pay them unless they win. You're more familiar with that type of a basis to hire a law firm for accidents and things like that, where they do it. But it's not as common in intellectual property cases. But if you've got a strong willful infringement case, the idea that the other firm, the other side, will have to pay your lawyers, or at least there's a chance they will have to pay the lawyers' fees and triple damages. That can definitely increase the odds that you could find a patent firm or a litigation firm that would take your case. So that's basically what a patent is. It is a constitutionally mandated, and then statutorily there's patent laws are in place, the statutes that give the United States Patent and Trademark Authority office the right to issue patents and examine patents and look at it. So if you have any questions, comments, please feel free, leave them. I will get them and try to reply to any answers, and we'll look forward to talking with you next time, and see you later.